Welcome back to Talk Testimonies. We're your source for really understanding those big Supreme Court decisions.
That's right. No need to wade through all the dense legal texts. We break it down for you.
And today, we're doing a deep dive into a really interesting one. BNSF Railway Company v. Michael D. Loos.
Yeah, this case tackled a pretty specific but important question. It was about payments for lost wages under FELA. That's the Federal Employers Liability Act.
Right, for railroad workers. And the question was, is that money considered compensation?
Exactly. Compensation that's subject to taxes under the Railroad Retirement Tax Act, or RRTA.
Okay, so let's get the bottom line out first. What did the court decide?
Well, the court sided with BNSF Railway.
Ah, okay.
They found that, yes, those payments for lost wages under FELA are considered compensation under the RRTA.
Meaning they're taxable for railroad retirement purposes.
Precisely. Subject to those taxes.
Okay, so now we know the outcome. Let's dig into the arguments. How do they get there?
It's fascinating, actually. Both sides had really distinct takes on the law and the precedents.
Let's start with BNSF Railway, the petitioner. What was their core argument?
Their main point was that these FELA lost wage payments are essentially remuneration paid for services rendered. That's the key phrase from the RRTA.
Services rendered. But the employee was injured, not rendering services. How did they square that?
Well, their argument was that the payment compensates for the wages tied to services the employee would have rendered or had rendered up until the injury.
Ah, I see. It's linked back to the employment itself.
Exactly. You can't get FELA lost wages unless you were providing services before the injury happened. It's tied to that prior service.
That makes sense.
Yeah.
Did they bring up any past cases to support this?
Oh, yeah. They pointed heavily to Nearco and Quality Stores. These cases looked at similar language in the Social Security Act and FICA.
And what did those cases say?
The court in those cases interpreted wages very broadly. Basically, anything connected to the employment relationship counts.
So kind of a wide net for what counts as compensation.
Right. Now, Loos tried to argue Nearco wasn't fully applicable anymore because part of it was modified later by another case, Cleveland Indians.
Okay.
But BNSF countered that, look, the specific calculation detail might have changed, but the basic principle from Nearco that pay for lost time is still fundamentally tied to the job that still stands.
So the core idea remained, even if some details were adjusted later.
That was BNSF's argument. They also made a pretty compelling point about the RRTA itself.
What was that?
They pointed out that the definition of compensation in the RRTA doesn't specifically say FELA lost wage payments are excluded.
Ah, the argument from silence.
Kind of. They basically said, look, Congress knows how to write specific tax exclusions when it wants to. We see examples elsewhere.
So if they meant to exclude this, they probably would have said so explicitly.
That's the idea. And they also raised a fairness issue.
Fairness. How so?
Well, they argued it creates an imbalance if employees get full retirement credit for these lost wages, which they often do under the benefit side, but don't pay the corresponding RRTA taxes on those same wages.
Right, getting the benefit without the contribution.
Yeah. And they even mentioned the Railroad Retirement Board's general practice.
The RRB, what do they usually do?
Apparently, the RRB tends to treat personal injury awards as covering lost time unless the parties specifically break it down differently in a settlement.
So the agency managing the system already kind of leans towards treating it like wages for lost time.
Seems that way based on BNSF's argument. It adds a layer of practical support to their view.
Okay, that's a pretty comprehensive case from BNSF.
Yeah.
Now, what about Mr. Loos, the respondent? What was his side?
His argument was, I'd say, more direct in some ways. He said, look, FELA awards are for injuries, not for services rendered.
Because he couldn't render services, he was injured.
Exactly. That was the whole point. He was physically unable to work, so how could it be payment for services?
Makes intuitive sense. What else?
He focused heavily on a change made to the RRTA back in 1983.
Okay, what happened in 83?
Congress removed the phrase, including time lost, from the definition of compensation.
Including time lost. Removed it.
Yes. And Loos argued this was a clear signal from Congress. They intended to stop treating payments for lost time, like his FELA award, as taxable compensation under RRTA.
So he's pointing to legislative action as proof of intent. What was the counter-argument to that?
Well, BNSF and the government supporting them argued that removing that phrase didn't change the basic definition. They suggested it was removed because it was kind of redundant.
Redundant?
Because other specific exclusions already existed in the RRTA, like for workers' comp, certain disability benefits. They argued those exclusions imply that lost time pay could fall under the general definition unless explicitly excluded.
Ah, so removing including time lost didn't narrow the main definition, just removed maybe an unnecessary example.
That was the counter argument, yeah.
Yeah.
Loos also drew a line between benefit laws and tax laws.
How so?
He argued that just because something counts towards benefits under the Railroad Retirement Act doesn't automatically mean it should be taxed under the RRTA. Different statutes, potentially different interpretations needed.
Okay, that's a key legal distinction he's drawing.
Definitely. And then there was the historical practice argument.
Right, you mentioned this briefly. The IRS.
Yes. Loos claimed the IRS hadn't really gone after RRTA taxes on FELA judgments historically.
Suggesting a kind of long-standing unofficial understanding that it wasn't taxable.
Exactly, a sort of this is how it's always been done argument.
But he said the government disputed that.
The U.S. government, acting as Amicus Curiae, a friend of the court supporting BNSF, pushed back. They said, well, maybe enforcement wasn't perfect, but our regulations have consistently indicated these payments are covered.
So a difference between official stance and maybe on-the-ground enforcement reality.
Potentially. Loos also brought up some very practical problems.
Like what?
Administration, especially with general jury verdicts.
Where the jury just gives a lump sum.
Right. They don't say X amount is for lost wages, Y amount is for pain and suffering. So how would the railroad or the IRS figure out the taxable chunk for RRTA?
That does sound messy.
Very. And connected to that, he mentioned jury instructions.
What about them?
Juries in FELA cases are usually told the award is not subject to income tax.
Okay.
Loos argued that telling juries one thing and then having the award taxed under RRTA anyway creates confusion and potential conflicts.
Yeah, you're telling the jury no tax, but that a different tax applies. Could be confusing.
Seems plausible. And his final point touched on that potential asymmetry again.
Between taxes and benefits.
Yes. He argued that not paying RRTA tax on a FELA award doesn't necessarily mean the employee loses out on the corresponding retirement benefits under the RRA. The two aren't perfectly mirrored, he suggested.
So a lot of angles from Mr. Loos. The nature of the payment, legislative changes, past practice, practical issues, jury confusion.
A very thorough counter-argument.
Okay, and let's quickly touch on the U.S. government's points again, supporting BNSF.
They largely echoed BNSF, but added some emphasis. They stressed that compensation under RRTA logically includes payments for time lost, just like sick pay or vacation pay.
Things we routinely accept are taxed even if you're not actively working that day.
Right, and they made that strong point about the existing exclusions in the RRTA.
The ones for workers' comp and disability.
Yeah, the government argued if compensation only meant pay for active work, why would Congress need to specifically exclude those things? It implies the general definition is broader.
That's a powerful statutory interpretation argument. You don't usually put unnecessary words in laws.
Exactly. They also hammered home the consistency point, how the Supreme Court has interpreted similar language in the Social Security Act for decades to include lost time payments.
Referencing that Nearco and Quality Stores precedent again.
Yes, showing a long line of similar interpretations. And finally, they highlighted the need for alignment.
Alignment between the tax side, RRTA, and the benefits side, RRA.
Correct. Since lost time payments do count for calculating retirement benefits under the RRA, it makes sense, they argued, for the RRTA tax rules to align with that. It creates a more coherent system.
Paying taxes on the same income base that generates your benefits.
That's the logic. Makes the whole system feel more integrated.
So wrapping up the arguments, it really came down to interpreting services rendered, didn't it?
Fundamentally, yes. And whether FELA lost wages fit, even though the service wasn't performed during the lost time.
And the court had to weigh legislative history, like that 83 amendment.
Precedent from related laws.
Practical administration issues.
And the overall structure and coherence of the railroad retirement system.
Plus that whole question of historical IRS practice. Lots of factors in play.
Definitely not a simple case.
So as we said at the top, the court found for BNSF, deciding these FELA lost wage payments are taxable compensation under the RRTA.
A decision that clarifies a long disputed point, but one with real financial consequences for employees and the railroad retirement system itself.
It really does highlight how interpreting specific legal terms impacts people's finances, injury compensation, retirement.
Yeah.
It's all connected.
Absolutely. Which brings us to our 10th chair segment.
Right. Let's imagine we're that hypothetical 10th justice. We've heard it all. Where do we land?
Okay, you go first. Justice number 10, what's your take?
Sitting in that 10th chair, I think I'd have to lean with the majority here. Loos's arguments about the injury preventing service in the 83 Amendment, they have an initial appeal, definitely.
Right.
But the link BNSF drew back to the employment relationship itself feels stronger legally, that these wages wouldn't exist without the prior service. And the government's point about the existing exclusions in the RRTA.
That if lost time wasn't generally included, those exclusions wouldn't make sense.
Exactly. That statutory interpretation argument is, for me, very persuasive. Plus, the idea of keeping the tax base somewhat aligned with the benefits base, the RRTA and RRA working together, just seems more logical for the system's health.
Makes sense. The administrative hurdles Loos raised are real, though.
They are, and that's a concern. But sometimes broader legal principles have to override administrative convenience. Maybe. That's likely where I'd land. What about you?
Well, I find myself agreeing. It's a tough call, and I see the force of Loos' arguments, especially the plain language he wasn't rendering services.
Right.
But the weight of precedent, particularly how similar language has been consistently interpreted under the Social Security Act for like 70 plus years, that's hard to ignore.
The Nearco and Quality Stores line of cases.
Yes. And the Quality Stores case, affirming that fairly recently in 2014, it suggests a settled understanding of this type of language in related federal benefits and tax law.
Consistency across similar statutes.
Exactly. And that argument about Congress knowing how to create explicit exclusions, if they wanted FELA wages out, they could have put it in writing, especially after all this time. The lack of that explicit exclusion speaks volumes, I think.
So symmetry and consistency seem key for both of us.
Yeah, aligning the RRTA with the RRA, or lost time does count for benefits, just feels like the more coherent reading of the overall statutory scheme Congress created for railroad retirement.
So a unanimous 10th chair leaning with the court's actual majority? Interesting.
It seems the arguments about statutory interpretation and systemic concurrence carried the day, at least in our hypothetical deliberation.
So for our listeners, this deep dive into BNSF v. Loos really shows how these complex legal interpretations directly impact workers and retirement systems.
It raises questions, doesn't it, about how we value lost work time versus compensation for injury itself, and how those values interact with our tax and benefit structures.
Definitely something to think about. How might this influence FELA settlements now? Will parties be more specific about allocating damages?
Potentially. It certainly adds another layer to negotiations and legal strategy in that area.
A fascinating look at the intersection of law, economics, and employment.
Indeed. Join us next time for another deep dive, exploring the cases and concepts that shape our legal world.